Since it's a few minutes after 6, we'll go ahead and get started with today's presentation. So welcome and thank you for joining today's presentation on the 2021 case law update involving community associations. My name is Kayleigh Long. I am the senior attorney here at Hirzel Law, and I focus my practice on association enforcement and litigation. So case law is definitely something I pay pretty close attention to. And I'm excited to give you an update on all the cases that came out of the Michigan courts from this past year. So we'll be going through about 13 different cases today. A lot of them deal with condominium associations, but some of them also involve homeowners associations as well. So there's something here for everybody. Before we get started, I'm just going to request that everyone keep themselves on mute, just so that way we don't have a lot of feedback. It makes it difficult for other people to hear what's going on. But feel free if you have any questions or thoughts you'd like to share about the cases that we're talking about, to type them into the chat box on the side of your screen. And I have the side of my screen up here, and I will do my best to catch those as I can and address those when I can. And then just so you know too, if you forget to put yourself on mute, I will probably mute you for you. It's not to be rude or meant anything by it. Just want to make sure that everybody can hear the presentation. All right, so we're going to go ahead and get started first with just an overview of the cases that we're going to be going through today. So like I said, about 13 different cases, and they can be classified into these 4 different buckets. One regarding the Michigan Condominium Act, the second, assessments and attorney fees, third, association approvals, and then fourth is just what I ended up calling grab bag, because they were all single cases that didn't really fit nice and neatly into any other section. And so you can see there we'll be dealing with developers, slip and falls, short-term rentals, insurance claims. And we're going to finish up with an interesting case out of Indiana regarding the Fair Housing Act. That is something that we are watching for some possible development in fair housing law there. So with all that said, we're going to go ahead and get started with our 2 cases regarding the Michigan Condominium Act. And we're just going to get right into the act right away with some statutory provisions. So I hope you came slightly ready to read some Michigan law for these first few cases. But the first case we're dealing with here involves 559.234. And as you can see, it addresses recreational facilities. And it basically says if there are going to be recreational facilities or other amenities, either in your condominium or in land next to your condominium, that the condominium has an obligation to support, financially support, then that operation of those facilities is going to have to comply with rules that we, the government, later on are going to decide to promulgate, because we want to make sure that everyone who's using those facilities is treated equally. And so in line with that, rules were later created at Michigan Administrative Code Rule 559.111. And as it applies to our particular case today that we're going to discuss, it specifically says if recreational facilities are owned by a third party and the co-owners are obligated to help financially support the recreational facilities, here are 4 or 5 things you're going to have to comply with. And what was at issue here were these 2 requirements that said that the co-owners have to have an equitable vote in the operation and management of those recreational facilities. And also the books and the records of those recreational facilities have to be kept separate from the other operations and have to be made available for inspection by the co-owners. So that is the legal landscape that sets up this particular case of File versus Chevy Investments Incorporated. So in this case, plaintiff owns a unit in an RV condominium project, and defendant is the successor developer for the condo. He also owns units within the condo, and he also owns recreational facilities located next to the condo. And the condo co-owners have a right to use with other third parties, so primarily other people who do not live in the condo, to use those recreational facilities, but they also have to pay towards those recreational facilities under the condominium documents. So the plaintiff co-owner argues that defendant had to operate those recreational facilities in compliance with NCL 559.234 and the administrative rules that we just highlighted, but that he had failed to do so. And so that as a co-owner, he was entitled to reimbursement for the fees that he had paid for those recreational facilities. On the other hand, the defendant argued that he did not have to comply with the Michigan Condominium Act because the association didn't receive the bill for the facilities. Instead, he just directly billed the co-owners. And he also said, look, I'm not a third-party owner of these recreational facilities. I'm a developer. I also own units in the condominium. And so based off of those arguments, he said, you know, you're not entitled to a reimbursement of fees because the condominium bylaws required you to pay those. And so the question at issue here was whether or not this defendant had to comply with the Michigan Condominium Act in operating his recreational facilities. And if so, was the plaintiff co-owner entitled to a reimbursement of the fees that he had paid for those recreational facilities? So the bottom line answer was yes. The Michigan Court of Appeals held that this defendant did have to comply with the Michigan Condominium Act when he was operating these recreational facilities. They specifically said that it did not matter who received the bill, whether the association received the bill from him for the recreational facilities or the co-owners directly. The Michigan Court of Appeals said, listen, the statute here says that it's designed to ensure the equitable treatment of all users. And if you can get around this provision, the statutory provision, just based on who you're billed, that's not, or who you're billing, that's not going to, satisfy the purpose of the statute and what the statute is trying to accomplish. So the Michigan Court of Appeals said, no, you got to still comply with the Michigan Condominium Act, and also told him as well that he was still considered a third-party owner because specifically the co-owners did not have an interest in the recreational facilities, such as general common elements or limited common elements. The developer owned those recreational facilities solely in his own capacity outside of any interest in the condominium. And so under all those reasons, the Michigan Court of Appeals said, you had to comply with the Michigan Condominium Act. You didn't give the co-owners an equitable vote. You weren't keeping your books and records separate and making them available for inspection to the co-owners. So you violated both the Condominium Act and the administrative regulations. On the second question of whether the plaintiff then was entitled to a reimbursement of his fees, the Michigan Court of Appeals said yes. And in doing so, they relied on Conlon versus Upton, which is another case out of the Michigan Court of Appeals, which says when validly promulgated, an entity's bylaws or similar governing instrument will constitute a binding contractual agreement between the entity and its members. And in this case, the Michigan Court of Appeals said those provisions within the bylaws requiring plaintiff to pay for the recreational facilities weren't validly promulgated because you violated the Michigan Condominium Act in your operation of the recreational facilities. And so with all that said, the takeaway from this case is that if your condominium's recreational facilities are shared, or if you share recreational facilities with somebody else, you need to make sure that they're being operated in compliance with MCL 559.234 and Michigan Administrative Code Rule 559.111. And you also need to be sure, and this applies for everyone, whether it's a condo association or a homeowners association, and whether you have shared recreational facilities or not, you need to make sure that any of your bylaws, including those requiring financial payments from your co-owners or your homeowners, comply with existing Michigan law and have been validly adopted. Otherwise, as this case shows, your entitlement to those payments may be rendered invalid by the court because there may not have been some compliance with Michigan law in the first place. I do want to make a note that this case is pending in front of the Michigan Supreme Court. The Michigan Supreme Court hasn't decided whether it's going to hear it or not. We anticipate that it likely won't be heard, but possibly at the 2022 case law update, we may have a potential update on this case depending on what the Michigan Supreme Court decides to do. And like I said, if you guys have any questions on these cases or want to talk through them more, feel free to add them in the chat box. I'll try to make sure I keep my eyes on the chat box and answer them as they go. But otherwise, I'm going to move to the second case dealing with the Michigan Condominium Act specifically today. And so again, put on your reading glasses, another look at the statutory provisions coming out of the Condo Act. We have here MCL 559.167. And if you joined us for last year's case law update, we talked about this provision last year too. And it's a provision that just keeps on coming back time and time again. So here in 2002, Section 67, Subsection 3 of the Michigan Condominium Act stated that if a developer did not withdraw need not be built units within 10 years after the date the developer commenced construction on the condo project, or 6 years after the condo was expanded, contracted, or portions converted, then those undeveloped units automatically became general common elements. No action was required on the part of the association or the co-owners. It just happened as a matter of fact. Later in 2016, that subsection was amended. And the one that is currently in effect now states that if a developer does not withdraw those need not be built units within the 10 years after the master deed was recorded, or 6 years after the condos expanded, contracted, or portions are converted, those undeveloped units now only become general common elements after the association takes a vote of its members to declare the unbuilt units are general common elements. Then they have to send a notice to the developer and give him 60 or her 60 days to withdraw or convert those units to must be built units. And then after that, the association can record the declaration. So it shifted it from this automatically just happens as a matter of law to you have to take a number of steps before that conversion from general common elements to, or a conversion from unbuilt units to general common elements will take place. So in this case, we have the Lakeside Estates condominium, which was created in 1994, and construction was supposed to end in 2000. However, construction did not begin until 1998, and developer ended up recording several amendments to extend that deadline all the way up until 2022. So about 24 years behind, or 22 years behind schedule. In 2019, he began construction on the last 12 units, which had been identified in 1994 as need not be built. However, the association filed a lawsuit saying those units had automatically become general common elements under Section 67, and therefore the developer had lost its right to construct those units. And so the question in this case was, does the developer still get to construct the remaining units? Does anyone have an opinion on it they want to share, take a guess, or we can go right into the answer? All right, so in this case, the Michigan Court of Appeals said, no, the developer does not get to construct those remaining 12 units. So the Michigan Court of Appeals said that the transfer had happened under this previous section of, or under this previous version of Section 67, and said basically under this, construction had started no later than 1998, And so no later than 2008, those 12 need not be built units have become general common elements. And so the developer in 2019 did not have a right to construct those units. Addressing the amendments that the developer had made to the master deed to try to extend that construction deadline, the Michigan Court of Appeals said basically that your rights were solely created by the Michigan Condominium Act. The Michigan Condominium Act allowed you or created your rights to construct these units. It also dictated what would happen to those units if you didn't complete construction within a certain amount of time. And so because of those statutory provisions, the developer could not just record amendments to avoid the consequences of that creation from unbuilt units to general common elements. And so the takeaway in this case is that the Michigan Condominium Act can give, but it can also take away at the same time. And that rights that are created and defined by the Michigan Condominium Act are still going to be controlled by the Condominium Act, and contractual provisions that attempt to work around and avoid the effect of the Michigan Condominium Act provisions may not always prevail. So in that case, just making sure that when rights are created by the Michigan Condominium Act, they're also going to be controlled by the Michigan Condominium Act, and you may not be able to contract or amend your way out of it. So those are the cases I have specifically for the Michigan Condominium Act. Other aspects of the Michigan Condominium Act will come up, but if there are any questions before we move to the next section, you can add in the chat box or feel free to unmute yourself and ask away. All right, so not seeing any questions yet, we will go ahead and now go into the second topic, which is assessments and attorney fees. And we have 3 cases for this particular section. So first up is, get the slide to move along. There we go. Litigation attorney fees and costs, something our associations love to know about, especially when they have co-owners or homeowners who violating the documents and can't get them to comply. So in this case, the association sued defendant co-owners because they had failed to maintain the exterior of their home, and the association asked to be awarded its attorney fees and costs as permitted by the condominium bylaws. In this case, the defendant just didn't even respond to the lawsuit. And so the trial court entered an order against them regarding the exterior maintenance of their home. And they awarded the association its litigation costs, such as, filing the complaint, those types of fees, but it did not award the association its attorney fees. And so the issue on appeal here was whether the association was also entitled to an award of attorney fees in this particular case. Does anyone have any thoughts on whether the association prevailed in the Court of Appeals or not? All right, well, the answer was they did. So in this case, their bylaws contained mandatory language that stated that in any successful proceeding arising from a default of a co-owner, the association shall be entitled to its attorney fees and costs. And so in this case, the defendants, failed to respond to the lawsuit. The association had successfully obtained a judgment against them. And so as a result, the bylaws mandated that the association be awarded its attorney fees and costs in this regard. And so the takeaway from this case is that associations with mandatory attorney fees and cost language within their governing documents remain entitled to those awards when filing successful lawsuits against co-owners and homeowners. So you'll just want to make sure you check that language within your documents, make sure that you have it in your documents, and make sure that it's mandatory as well. There are now several cases out of the Michigan courts saying when you have that shall be language in there, an award of attorney fees is required. All right, up next is Channelview East, Condo Association versus Ferguson, and this deals with fines and foreclosures. So this case, it does get into the Michigan Condominium Act, and so we'll take a look at a few of those provisions when discussing it. But in this case, defendants began construction of their home in 2003, but by 2005, they had not completed construction in violation of the requirement that construction had to be complete within 12 months. So from 2005 through 2017, defendants accumulated $137,800 in unpaid fines, all stemming from this one violation. And the association finally sought judicial foreclosure of the lien on the unit, alleging that the unpaid fines were unpaid assessments that constituted a lien on the unit. And so the issue up in front of the Court of Appeals was whether those unpaid fines actually did constitute a lien on the unit that the association could then foreclose. And the Michigan Court of Appeals, and reading two statutory provisions from the Michigan Condominium Act, ended up saying no, that they didn't constitute a lien. And so specifically the provisions that they looked at were first MCL 559.206A, which says, failure to comply with any of the terms or provisions of the condominium documents are grounds for relief, which could include foreclosure of lien if in default in payment of assessment. And so in taking that language in specific reference to assessment, the Michigan Court of Appeals then looked at 559.208 subsection 1, where it says here that sums assessed to a co-owner by the association that are unpaid, together with interest, collection charges, attorney fees, and fines in accordance with the condo documents, constitute a lien upon the unit. And so in reading those two provisions together, the Michigan Court of Appeals said that the condominium documents in this particular case did not define fines as assessments. And unless the fines were an assessment, that the association would not be able to foreclose a lien that was solely based on unpaid fines. There had to be an underlying unpaid assessment attached to that particular lien in order for the association to move forward with foreclosure. And so the biggest takeaway from this case is that associations that have delinquent accounts that solely consist of unpaid fines need to make sure that they carefully review their documents to determine whether fines are defined as assessments within their documents before proceeding with foreclosure. And if that language doesn't exist, associations might also want to consider amending their governing documents to specifically clarify that fines are assessments in order to avoid being unable to move forward with a foreclosure unless and until there are also unpaid assessments on the account. So in this particular case of Channelview, there weren't any unpaid assessments. The lien only consisted of unpaid fines. And so that was what the court was looking for, is where are the unpaid assessments? And because fines weren't defined as assessments in the condo documents, the court said, you're not entitled to foreclose the lien at this time. All right, so moving on. And I will also say before we move on, this is something that local firms, including our firm, are taking a look at and attempting or hoping to put forth a bill in the Michigan legislature to amend these statutory provisions to make it more clear that you could foreclose a lien just based off of fines, and that a fine would be considered an assessment. So that is something that is on the table and on the horizon if the Michigan legislature decides to pass it. Then in the meantime, associations, condo associations should still take a look at these and make sure, or take a look at your governing documents and make sure you have language regarding fines being assessments. All right, next up, also another Michigan Condominium Act read of the provisions, but also still dealing with foreclosure. Again, reading glasses for these next two slides for these statutory provisions. So this first one is out of the Michigan Condominium Act 559.208 subsection 2, which says that a foreclosure under the Michigan Condominium Act has to be conducted in the same manner as the laws relating to foreclosure of real estate mortgages by advertisement. So other foreclosures that are not happening, that are happening by advertisement, but not happening in the world of condos, those have to be conducted in the same way. But it adds specifically that the redemption period for foreclosure is 6 months from the date of sale, unless the property is abandoned. So that's the Michigan Condominium Act's language on foreclosure. Then when you look at the other language regarding foreclosures under advertisement, just based off of other real estate in general, there's this provision here at 600.3238 subsection 6 that specifically says, if an inspection under this section is unreasonably refused, or if damage to the property is imminent or has occurred, then the purchaser can immediately commence summary proceedings for possession of the property. Essentially, that the purchaser can immediately cut off the redemption period and take over the property sooner rather than later. And so with those two provisions, we end up with a question on a condominium lien foreclosure, where a co-owner, she fails to pay her assessments for units foreclosed by advertisement under the Michigan Condominium Act. So that first provision that we looked at. And so from the date of her foreclosure sale, she has 6 months to redeem her unit. However, about 1.5 months into that period, the defendants who had purchased the unit at the foreclosure sale asked the district court to end that redemption period early and evict her from the unit because she had failed to permit an inspection of the unit. So they relied on that provision that exists outside the Michigan Condominium Act. The district court ended up terminating the redemption period early, and they granted title to the unit and the defendants. However, a few months later, the co-owner asked the judge to set aside that earlier order, and she tried to sell her unit to the plaintiff, a different buyer. And she claimed that the 6-month redemption period under the Michigan Condominium Act controlled and was still running, notwithstanding the district court's earlier order. And so in this case, the Michigan Court of Appeals was looking at who owns the unit. Did the 6-month redemption period provided for under the Michigan Condominium Act, did that have to continue running, meaning that the plaintiff would own the unit? Or did this outside provision for other general real estate foreclosures also apply to this situation, cut her redemption period early, and then mean that the defendants own the unit? So in this case, the Michigan Court of Appeals held that the defendants own the unit. And so they focus on the fact that the Michigan Condominium Act, if you read it, says that it will be in the same manner as a foreclosure under these other laws. And so the Court of Appeals had said that this provision incorporated by reference those other laws. And so the Michigan Condominium Act and these other real estate foreclosure laws have to be read together, and they work together. And so the Michigan Condominium Act's specific provision regarding 6-month redemption period does apply, but it's also read together with this provision saying, if you fail to, or if you unreasonably refuse to permit an inspection, your redemption period can be cut short. And so the Court of Appeals read those together and ended up saying the judge could terminate the redemption period after a month and a half, and the defendants end up owning the unit. And so the takeaway for this particular case is that it's largely a statutory interpretation case, but the foreclosure statutes within the Michigan Condominium Act are going to be read together with the other mortgage foreclosure statutes. And so they don't necessarily exist in two silos. They really operate together in many respects. All right, so we are going to get ready to move into the next section of association approvals. And we have about 4 cases in that, or 3 cases in that one. So I'll just pause and see if anybody has any questions up till this point. I think we're basically done with all the statutory cases at this point in time, primarily. So I think we've got the bulk of it over. All right, so seeing no questions, we will discuss association approvals. So I excerpted here, this is the first paragraph of this opinion that came out of the Michigan Court of Appeals. And I love the setup of this language. And so I wanted to highlight it and read it. Poets and painters have long been inspired by the serenity of fountains, the softly flowing water, the majesty of their form. But one person's nirvana can be another's nightmare. And modern subdivisions, homeowners associations, craft rules, and regulations for outdoor aesthetics to maintain harmony among neighbors of differing tastes. When residents break the rules, they may be required to dismantle their peaceful oases. Monorural and Shortman Talector required pre-approval to install any outdoor feature that could be seen from neighboring lots. They custom ordered an expensive 9.5-foot fountain as if pre-approval was of no consequence. Installed the fountain after Steeplechase and Northville Owners Association denied their application and ignored Steeplechase's order to remove the fountain. So I thought that that opening paragraph was very interesting. I feel like many times these opinions don't have such creative opening lines. So in this particular case, we're dealing with a set of approval requirements within condominium documents. And so we have here where you're supposed to submit or ask for approval before you make certain changes, which would include this fountain. And in this case, the committee is supposed to act within 45 days once it gets the application. And if it fails to act within that time, it will constitute an automatic referral to the board of directors at the written request of the applicant. And when it gets sent to the board of directors is supposed to answer that written request for approval within 15 days. And if they don't act within that 15 days, then the application is deemed approved. And so in this case, we have the co-owners who submitted an application to the covenants committee, and the covenants committee didn't act within the 45 days. And then a series of at least 15 days follows after that. The co-owners don't hear anything, and so they say, all right, under the language of the documents, this is deemed approved, and we're going to install this 9.5-foot fountain. And so the questions were, in this particular case, whether the co-owner's application had been automatically approved by the covenants committee and by the board when both of them had failed to act within the time frame that was given, and did they end up having to remove their fountain? And so at the end of the day, as you can probably tell from the opening paragraph of that case, they did end up having to remove their fountain. And the Michigan Court of Appeals got really into the language of these provisions, specifically regarding the covenants committee and the transfer over to the board of directors. And so they focus here on the highlighted part, which says that it would constitute an automatic referral to the board of directors at the written request of the applicant. In this case, the co-owners never requested the Governance Committee to refer this to the Board of Directors. And so the Michigan Court of Appeals said it's not approved. It never went to the Board of Directors. So the Board of Directors did not have their 15 days to review it. And so at the end of the day, your fountain's not approved. The takeaway from this one is a lesson for both associations and homeowners alike. So first, associations need to make sure that they carefully review and follow their approval processes, which might require you to act within a certain amount of time before a request is deemed approved. And then homeowners, for their part, just need to carefully review those provisions before proceeding with expensive construction that you think has been automatically approved because no one has acted, but actually may not have been approved. So that a very interesting read from the Michigan Court of Appeals. Next up, discussion on amending bylaws and association approvals. So the condominium association's bylaws state that the developer has architectural control rights over the homes in the condo, and its approval has to be obtained prior to construction. The bylaws state that the developer can assign those rights to the association or someone else. And in this case, no one has been assigned those rights. Later, via board resolution titled as an amendment to the master deed, the association states that it's the developer's successor, and therefore all approvals have to be obtained from the association. The defendant ends up deciding to build homes, but he doesn't get the association's approval, and the association files a lawsuit against him. And so the question before the court is, did the defendant have to obtain the association's approval before building its homes? The Michigan Court of Appeals said no. And they specifically focused on, again, looking at the fact that this is a condominium association, that they had not complied with their bylaws amendment process, which required that an amendment to the bylaws go through a co-owner vote. And so here they needed 2/3 of the co-owners to approve this board resolution titled as an amendment that would have made the association the developer successor and therefore in charge of the association approvals. Instead, here, the board just adopted the resolution themselves and said, here we are the developer successor, approvals are to us, and the Michigan Court of Appeals said, that's not enough, you gotta comply with the Michigan Condominium Act. The takeaway for this case, whether you're a condo or a subdivision, is that you need to make sure that you follow your amendment provisions within your governing documents. And if you're a condominium, you need to comply with the amendment provisions within the Michigan Condominium Act. A lot of amendments, particularly under the Michigan Condominium Act, are going to require approval of your co-owners, and failure to follow those processes may end up dooming your amendment. So make sure you take a look at those. Make sure you're getting votes when you need to. All right, next up in association approvals, and this is the last case, is Hahn versus Lake Doster, Doster Lake Association. This is one of our few cases coming out of the Michigan Supreme Court this year. And if you participated in last year's case law update, you'll probably remember we talked about this case and the decision that the Court of Appeals had made. And that Court of Appeals decision was ultimately appealed up to the Michigan Supreme Court. The Michigan Supreme Court took the case, and the Michigan Supreme Court disagreed with the Court of Appeals. So in a 2-1 decision, the Court of Appeals had held that a developer's oral approvals to backlot owners to erect docks on a lake were valid and irrevocable easements, as opposed to mere licenses. And the association could not later require those lot owners to relocate their docks, despite the fact that oral approvals did not comply with the recorded restrictions requirements for obtaining approval for these docks. So just to kind of summarize that and clean that up a little bit. We have here a lake that's part of the association, and under the documents, you're supposed to get written approval to locate a dock on the lake. In this case, the developer was just giving out oral approvals, never confirming it in writing or having those approvals recorded. And later on, the association says, hey, we need to move these docks. And this approval process hadn't been complied with. And so we have authority to come in and say, you have to move your docks, wherever we tell you to. And the Court of Appeals said, actually, no, they don't have to move them. We think that this is enough to create an easement. You can't make them move them, without their permission or without their agreement to do so. And a lot of their argument too was based off of the financial money that these particular lot owners had invested in creating these docks and getting them set up. And so, like I said, the association ends up appealing the Court of Appeals decision to the Supreme Court. And the Supreme Court disagreed with the Court of Appeals and said the association can require them to relocate those docks, notwithstanding the fact that the developer had given them prior oral approvals to construct and locate their docks where they did, and despite the fact that they may have invested a decent amount of money in constructing and locating the docks where they did. And so the Supreme Court said, listen, because these were only oral approvals, these were just licenses, which means, sure, you can put your dock here, but I can revoke that at any time I want. And so it's a non-permanent interest in land. Easements, on the other hand, which is what the Court of Appeals had said was involved here, is a permanent property interest and would have, given these particular owners more lakes to stand on, but those are required to be in writing. And because here we're dealing with oral approvals and not dealing with writing, all that was given in this case was a license, notwithstanding the fact that a lot of money was involved. And so here the owners did not have an easement, and the association could tell them that they were going to have to remove or relocate their docks. So the big takeaway from this case is both homeowners and condo associations make sure to follow the approval process in your governing documents, and always make sure to document modifications, alterations, and approvals in writing. And also too, many associations, or I shouldn't say many, but some associations may have, rights to use land around them. Maybe you're friendly with a condominium next to you, and they allow you to access, certain items, and it's not really documented in writing. And so you should make sure that you also understand what your rights and property are, particularly if you have those informal setups or informal agreements. So, do you have a license with that particular association or with that particular person that at the end of the day, they could just revoke if they wanted to? Or do you have an easement and a non-revocable right to use that land? So that case should be done now, since it got resolved at the Michigan Supreme Court, but a really important lesson on making sure that you follow your approval process and make sure everything is in writing. All right, so before we deal with the grab bag of cases, again, just pause to see if anybody has any questions. All right, seeing none, we will go ahead and start. We have, I believe we have 5 cases in the grab bag. So one is going to start with developers. So this first one involves a developer who ends up losing his units to his mortgage company through a mortgage foreclosure sale. And then they sell some of those units onto the plaintiff, along with some development rights. And so Later, while plaintiff still owns some of those units, the association decides to amend the leasing restrictions, but doesn't get the plaintiff's approval. The plaintiff then sues the association saying, hey, I am the developer under the condominium documents, and the condominium documents say that you have to get my prior written consent for this amendment. And because you didn't get my consent, this amendment isn't valid. The association argued, on the other hand, that the plaintiff was not a developer, and so therefore its consent was not required and the amendment was still valid. The Michigan Court of Appeals then had to answer the question of whether the plaintiff was a successor to the developer, even though it didn't receive units or developer rights directly from the original developer. And then, of course, based off of that, whether the association had to get their prior written consent for the amendment. And the court in this case held that this plaintiff was a successor to the developer. And they particularly looked at the language within the purchasing documents. So the documents that had conveyed rights from the original developer to its mortgage company, and then what the conveying documents from the mortgage company to the plaintiff. And so looking at the language within those particular documents and the definition of a developer and these particular condominium documents, the court said that this plaintiff was a developer and therefore its prior written consent was required for this particular amendment. And so because the association didn't get that consent, the amendment was not valid. So for here, the question, particularly for our condominium associations, some of who might be going through different developers changeovers of, one developer maybe going defunct and selling on units to other people, determining whether a particular purchaser qualifies as a successor or an assign of the original developer, or as a successor developer under the Michigan Condominium Act, does require a careful review, not only of the language within the condo documents and the Condominium Act, but also in the purchasing documents, and in the documents that are conveying the property interest from one person to the other. And so this case is really an important lesson for associations who are trying to figure out whether this new purchaser qualifies as a developer or not, that you might need to end up investigating beyond the first purchaser of the units, and that someone can be a developer even if they didn't buy it directly from the original developer. All right, so next up, something I'm sure we're all particularly interested in as winter has approached is slip and falls. So here, plaintiff leased a unit within the condo. The units were on a cul-de-sac and actually were only accessible over the limited common element driveways. So there wasn't necessarily a sidewalk or particularly a lot of grass. There wasn't a lot of land or ground outside of the driveways that you could use to actually access your unit. And so the association was responsible for plowing the road and the driveways, while the co-owners were responsible for shoveling the sidewalks. Plaintiff's driveway was icy due to a previous snowfall and freezing temperatures. The icy nature of the driveway was visibly apparent, but he did not attempt to remove the ice or salt his driveway. And so he gets a neighbor ask him for assistance in unlocking her car. And so he begins carefully walking down his driveway, but he ends up slipping and falling and sustains serious injuries to his ankle and leg. And he sues the association because they had failed to provide proper snow removal and salting services. So the Court of Appeals was asked to decide whether the association should be liable for his injuries. And the Michigan Court of Appeals said no. And so this is based off of a legal principle called premises liability, which is his claim ended up failing because the association may have had a duty to exercise reasonable care to protect others from unreasonable risk of harm caused by dangerous conditions on the land. And, an icy driveway, likely was a dangerous condition, but it does not extend to open and obvious dangers. And so in this case, as noted, the plaintiff saw that it was icy. He knew it was icy, but he still decided to proceed walking on the driveway anyway. And so the Court of Appeals did comment that they were particularly concerned that there was not a lot of accessibility to the units outside of this driveway, which was icy. And so if he was actually trying to go to enter his unit or leave his unit, the association may have faced some liability in this aspect, but instead he decided to engage in a discretionary activity, which was to walk to assist a neighbor. And the Michigan Court of Appeals said, hey, he could have just driven his car to, go across the street and help her. He didn't necessarily have to walk to help her with that activity. And so the Court of Appeals said, he could have really avoided this danger. And so the takeaway for this case is that associations might be able to avoid premise liability claims if the danger is open and obvious, such as here where we have ice and it's visibly apparent to this particular or to the particular homeowner. But even in situations where a danger is open and obvious, such as an icy driveway, there might be liability if it becomes what the court says effectively unavoidable. So again, an instance where maybe there's only one way to get in and out of your unit. And if that thing is covered with ice and you're not going to be able to leave or get into your unit without going through that area, that might be a potential case where some liability might exist. All right, short-term rentals. So this is primarily, it's helpful for condos, but definitely helpful for our subdivisions that have some older restrictions. So in this case, defendants owned a lot that was subject to a restrictive covenant that limited the land to residential use. Did not specifically mention short-term rentals, and also contained an anti-waiver provision saying that a failure by the association to enforce its covenants cannot be deemed a waiver of its right to later enforce those same restrictions. So defendants here used their lot for short-term rentals, and the association sued them, saying that the short-term rentals were not a residential use. The defendants then said that, hey, the restrictions don't expressly prohibit short-term rentals. The short-term rentals are a residential use. Our renters are using them to stay in there, sleep, eat. And the association had allegedly failed to address prior short-term rentals in the subdivision. And they argued that because you failed to address these prior ones, you can't now prohibit us from engaging in short-term rentals. The question for the Court of Appeals was, first, whether defendant short-term rentals were a residential use, and if they weren't, what impact were the prior short-term rentals going to have on defendants' abilities to short-term rents? The Michigan Court of Appeals decided that these short-term rentals were not a residential use. And one thing, some language that they specifically incorporated from the trial court was that listing a property on an online platform for money is not a residential use. And the Michigan Court of Appeals reaffirmed several cases coming out of their court regarding short-term rentals and what constitutes a residential use, saying that it requires something more than just a temporary transitory presence. There has to be some evidence of an occupant's intent to establish a permanence to their presence there. And with short-term weekly rentals, that just is not enough of a permanent presence to make it consistent with a residential use. The second question is the impact that the prior short-term rentals had on the defendant's ability to short-term rent now. was that the Court of Appeals said, first, you didn't give us enough evidence of what these prior short-term rentals were. The court said that you have to show that these short-term rentals were widespread throughout the subdivision. They only pointed to maybe a few. And also too, that the short-term rentals had changed the character of the neighborhood. So much to the point where the residential use restriction wouldn't have been, beneficial to anybody. And the Michigan Court of Appeals agreed with the trial court in saying, evidence of maybe a few short-term rentals, but not a ton, and not any evidence that the character of the neighborhood has changed is not enough to make out a claim for waiver. And both the trial court and the Court of Appeals too also focused on the anti-waiver provision and said, even if you had, presented us with this evidence, this anti-waiver provision says that the association could still enforce it down the road, even if it hadn't enforced it in the past. The takeaway for this case is, communities, particularly subdivisions that only have residential and commercial or business use restrictions, but may not have language specifically regarding short-term rentals, may still be able to restrict those short-term rentals. And based off of those residential and commercial business use restrictions. And associations that have anti-waiver provisions within their documents, it can be extremely helpful for them in later enforcing restrictions that maybe prior boards didn't necessarily rigorously enforce before. And so, if you're a new board coming on and prior boards have been a little lax in enforcing some of those restrictions, those anti-waiver provisions are definitely helpful for associations who want to start taking up and more vigorously enforcing their restrictions. All right, two more cases. Second to last one is insurance claims. So here we have a case where they try to go all the way up to the Michigan Supreme Court. Michigan Supreme Court decided not to take it, but back in 2016, the plaintiff's condo basement began flooding with water, and she submitted a claim to her insurance company, and the association also submitted a claim to its own insurance company on her behalf. So many associations will do this to say, hey, if we have any coverage, we're willing to do all in this regard. And so the association's insurance company did end up issuing her 2 checks, but she rejected both of them because for her, they weren't enough money. And then she later sued the association and the insurance company, saying that they had breached the insurance contract, by basically not giving her the amount of money that she thought she was entitled to. And so the Court of Appeals had to address the question of, did the association and insurance company actually breach their contract? Did she have a breach of contract claim against them? And so in this case, the Michigan Court of Appeals said no, and she wasn't a party to this contract, so she couldn't bring a breach of contract claim against them. And they focused primarily on this, trying to think of a good word to describe it, this contract principle of beneficiaries and whether someone is an intended beneficiary or an incidental beneficiary. And the court said, listen, third parties cannot bring a breach of contract claim against someone when they're not a party to the contract, simply because they might benefit from the contract, or they might be injured by a breach of this contract that they're not a party to. And so that is described as an incidental beneficiary. You're not a party to it. Your rights and your rights or any of your entitlements are not really contemplated by the agreement, but you might just happen to benefit from it. And so those are incidental beneficiaries. Instead, this particular court had to show that she was an intended beneficiary, which means that the association and insurance company had specifically undertook a specific obligation for her and their contract. And so in this case, There was no language in the contract that specifically identified her or otherwise identified her as a third-party beneficiary. Because of course, the association was just, looking for an insurance policy to cover its obligations under its condominium documents. So this case just goes to illustrate that co-owners and homeowners, they might benefit from an association's insurance policy, but generally those co-owners are not going to have a right to enforce that insurance policy unless they can demonstrate that they are an intended third-party beneficiary of that contract. Thanks, Sarah. We're almost wrapping up. I know we're a few minutes beyond 7, but this is our last case. And this case actually comes out of the state of Indiana. So it is not a Michigan court case, but it is an interesting case in developments of hostile housing environment claims under the Fair Housing Act that we're keeping an eye on. So in this case, this is out of Indianapolis. Plaintiffs were a Black family who rented a home within the association, and the association had a restriction that prohibited offensive and nuisance activities and authority to file a lawsuit against owners who violated those restrictions. So something we commonly see here with our condo and subdivision associations. Defendant was a white woman who lived across the street from plaintiffs, and she engaged in a pattern of harassing and bullying behavior against plaintiffs, including the use of racial epithets. And the opinion in this case also shows that she engaged in similar behavior with other people as well, who weren't parties to the case, but this was kind of her modus operandi. Plaintiffs repeatedly contacted the property manager and association, and the association just responded with some cease and desist letters. However, at the same time, she became delinquent in her dues, and the association filed a foreclosure action against her that ended up ultimately being unsuccessful. So plaintiffs later filed a lawsuit against the property management company and association under the Fair Housing Act for not taking more aggressive action against the defendant for her racial harassment and permitting the existence of a hostile housing environment. And so the question that this federal district court had to answer is the property management company association, did they violate the Fair Housing Act when they failed to file a lawsuit against this defendant for her racial harassment that she was committing throughout this particular neighborhood? And in this case, the district court didn't really give an answer and basically just said maybe. And so the opinion in this case was related to whether the plaintiffs were going to be able to maintain their claim against the property management company and association at all. Basically, whether they had a claim to bring at all. And the court said, these claims can continue against them. But there's still a question of whether the company and association actually violated the Fair Housing Act by failing to file that lawsuit. While at the same time, they had also filed a lawsuit against her when she hadn't paid her dues. And so I think some associations might be surprised by this particular case because it seems like a neighbor to neighbor dispute. And, associations and property managers may be wondering, how much are we supposed to get involved in these? What type of action are we supposed to take? But this case illustrates a new or within the last few years, a new development under the Fair Housing Act is regarding hostile housing environments, which is the potential liability. And so here, liability for these claims can come from the person's own conduct. And so in this case, that would be the defendant homeowner and her own actual harassment of these particular individuals. Failing to take prompt action to correct and end a discriminatory housing practice by you're an employee or your employee or agent, so cases of a potential employer-employee relationship, but also failing to take prompt action to correct and end a discriminatory housing practice by a third party where the person knew or should have known of the discriminatory conduct and had the power to correct it. And so one thing that the district court is going to be looking at is the fact that the association's governing documents did permit it to file a lawsuit against this defendant for engaging in this particular activity. And the question that that court is going to have to answer is whether their failure to file that lawsuit is enough to hold them potentially liable under the Fair Housing Act for that behavior. And so the big takeaway from this case is associations frequently want to stay out of what appear to be neighbor-to-neighbor disputes. And I think that in many instances, there is a desire to be hands-off with those neighbor-to-neighbor disputes. However, associations do need to be careful in taking that hands-off approach in all situations, particularly if they do involve harassment on a protected class, such as race, national origin, sex, or religion. The Fair Housing Act does allow associations to be held liable for these hostile environment claims if the association knew or should have known of the conduct and had the ability to address it, but failed to do so. So just, a word of caution and a reminder of sometimes they're purely just neighbor to neighbor disputes, and the association, might want to stay out of them. But if they start getting into the realm of harassment based off of protected classes and the association is aware of that conduct, the association is going to want to take a more proactive and aggressive approach to that. All right, so that is the end of the presentation. So I will leave it open for a few minutes if anyone has any questions. Otherwise, I know that this is going to be up later on YouTube. So if you really enjoyed it, you can watch it again. Or if you have any other questions, my contact info is here on the slide and you can feel free to contact me.